Friends, I just pressed the Let's Go Live button, so that means we got to wait for the stream to fire up all across the fruited plain of the interwebs before we go ahead and get started. Now, YouTube was giving me a little bit of grief today, so hopefully we're coming in loud and clear over there. We're alive and well over on Locals. Our friends on Rumble are here. It's looking good. It's a Friday. It's a good Friday, and that means we can go ahead and get started because we have a drop that we have to get to today. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Big Fani Willis there in Georgia and the disqualification appeal that is now on the docket over there in Georgia. We see here that Steve Sadow, Trump's defense attorney, dropped this one at the close of the Good Friday, and it is good indeed. We're going to get into this one in detail because it is a big one. We got over 30 pages to unpack together, and it's good news. Remember that Judge Scott McAfee, the so-called judge there in Georgia, he gave the defense permission to apply to the Court of Appeals to appeal. And so they have submitted that, the application for the interlocutory appeal, which is the appeal in the middle of the criminal case. Most criminal cases, you appeal at the conclusion of the case, but they're asking for a pause to go up to the next level court. And so we're going to read through all of that and see what is inside, because there is some goodness in there. Phil Holloway, of course, has some details on how this is going to work. And so we'll see what he says about it. But we've got one segment on this beautiful Friday, and we're excited to get into it and see what is in there. This morning, we had a great members only stream. Of course, we'd love to have you as a member only, our member only community. Great way to support what we do here. And it's a great community. We do try to make it really valuable. So we do a bunch of streams in the morning, streams on Saturday, and we do an after party after the show on Locals. So come check it out, watchingthewatchers.locals.com. We would absolutely love to have you. We also have robertgouveia.com, which is our website where we post all of our PDFs. We also clip the show, make segments, and turn them into reports so that you can share those reports with your friends or family, access the PDFs, sign up for our newsletter, access the calendar. We now have a calendar there so you can see what is coming up in the different court proceedings, and the show is scheduled there so you can follow along with everything that's happening here in the Watcher community. And of course, WatcherLodge.com, which is our sovereignty and self-development community. And we got some fun stuff that I'm getting scheduled right now as we speak. More on that next week. We also have the shopping tab, which is now available on YouTube. So if you're looking to get some new gear, some nice new polos, I tag some of the polos that I wear on the shopping tab in YouTube. You can load up your cart from Nordstrom's, whether it is men's clothing, women's clothing, whatever. Just click our link, follow on over there. Get some good stuff this summer because you got to look good, especially while you're watching the show. You know, look good. All right, so check that out at the shopping tab on YouTube, and thanks for supporting our work. Any which way, we are grateful to have you here. And it is a beautiful Good Friday, my friends. I hope you are having an amazing weekend, and that you are planning some activities for how you'll be celebrating this Easter. If that is something that you do, of course we will. But before that, we're not done with the week yet. We got some business to attend to, starting with Fani. Fani gets appealed. Trump defense attorney Steve Sadow and other co-defendants are now taking this up in Georgia to the Georgia Court of Appeals. We're going to read through the full filing and see what is inside, because the last appeal document that we got was just basically permission to appeal. Remember, in Georgia, they got to get permission to take it up, and the Court of Appeals still needs to accept it. But this is the application from the defense that's saying, hey, Judge Scott McAfee, your opinion was terrible. Fani Willis perjured herself in court, in your courtroom, lied to you, and she should have been gone for many, many reasons. Of course, he decided not to do that and decided to save her as long as her boyfriend left. Well, that was good enough for that courtroom. So this is what Steve Sadow, Trump's defense attorney extraordinaire, who's done a great job on this, he posted this as he submitted this application for an interlocutory appeal. And as we talk about here, most appeals happen at the conclusion of a criminal case. This is not obviously a standard case as much as they want it to be. And so they're asking for permission to kind of pause the criminal case, settle this issue. This issue is so consequential that if it is dispositive, if they decide to get rid of Fani, it might get rid of the whole case. So you can't really correct this at the conclusion of a trial, and they want to get this settled right now. So here's what Mr. Sadow said on behalf of Trump and the other co-defendants in this filing. He submitted it saying, President Trump and 8 other defendants filed their joint application for interlocutory appeal today. Now, defendants argued in the trial court to Scott that the indictment should have been dismissed, and at a minimum, that DA Willis and her office should have been disqualified from prosecuting the case. Now, we know that Judge McAfee did not do that. Sadow says the Georgia Court of Appeals should grant the application and accept the interlocutory appeal for consideration on the merits. Submitted from Steve. And so let's just get right to it, my friends. This is the appeal. It is the application for interlocutory appeal. And the way Georgia works, again, permission from the judge below, permission from the judge above, then the full court in the Court of Appeals will accept it. But this is a lot more substantive than the filing that we were asking for back down in, or we were reviewing and asking Scott McAfee for permission to go up to the next level court. Here's the case. Case is, of course, Donald Trump as defendants with many other co-defendants. It is the state of Georgia charging them with numerous crimes. But here they are the appellants. They want to appeal this. The state of Georgia responding. You see, all of the lawyers are here. We're familiar with all of these amazing people. Shout out to Steve Sadow, Stockton Esposito, Jennifer Little. We've got David Lewis, McDougall. We saw Catherine Bernard. We got Christopher Anowitz, Richard Rice, Todd Harding, Christopher Kacharoff. Man, look at all these people. Shout out to Craig Gillen, Cromwell, Pearson, and don't think I skipped her. We were just saving her for last. After James Durham, D. Lewis, and Joe Esposito, we're talking about Ashley Merchant in the House, defense attorney extraordinaire for Michael Roman, who really kicked this whole thing off. And so here is where this goes. So this is on appeal from Scott McAfee's courtroom up to the next level in Georgia. We fast forward through the table of contents and all the citations. And here is what the defense says. As Big Fani Willis isn't done yet. Sorry, Fani. We're going to see what the Court of Appeals has to say about your perjury. So pursuant to the rules and to the law, the defense says we are here applying for leave to appeal Scott McAfee's order that didn't disqualify Fani. Saying, all right, here, Court of Appeals in Georgia. All of us as attorneys, we're going to say Steve Sadow's taking the lead on this, but we'll say, here, your honors, at the Court of Appeals in Georgia, the defendants here were indicted by Fani. Let's get some background on this. In August 2022, for their alleged actions related to the 2020 presidential election. Now, at issue here is whether DA Willis and her entire office should have been disqualified from prosecuting this case based upon DA Willis's inflammatory out-of-court statements regarding defendants and their counsel and other misconduct in response to this motion. Now, while the trial court factually found that DA Willis and her out-of-court statements were improper and that the defendants proved an apparent conflict of interest, for some reason, Scott McAfee, the judge, said as a matter of law that Willis could stay. And by doing so, he erred by not requiring Fani to also go. And this legal error requires the court's immediate review. And this, I wanted to look something up briefly. And when was this? All right, we'll come back to that. So here we got this. Now, an erroneous interlocutory appeal. So this is Sadow continuing, saying an erroneous interlocutory trial order that will cause substantial error at trial, right? So this whole thing, like, think about it this way. If Fani is not precluded, if she's not removed, we have a corrupt, perjuring, lying prosecutor who's going to be on this case for the rest of the case. So her misconduct will continue to taint the rest of the trial. So we have to address this now. Like, we're not going to have a fair trial until this issue is settled, which is why we have to pause this criminal case and settle it now. So here they say the March 15th order from the trial court that's declining to disqualify DA Willis invokes both criteria. Now, first, the erroneous failure to disqualify a prosecutor is a structural error that McAfee committed that would not just cause substantial error at trial, but it would render each and every trial in this case a nullity, right? How can you possibly have a fair case against a cheater? Now, given the complexity of this case, the fact that it likely will be conducted through multiple different trials, given the number of different defendants and the projected length at each of these trials is estimated by the state to be at least 4 months each, but likely even much longer than that. The time and the resources that the courts and the parties and the taxpayer of Fulton County are going to be forced to expend through this process is massive. All right, if you don't settle this, we're going to have to go through trial on every one of these things. All right, and then we might discover once you do settle this, oh yeah, Fani's corrupt as heck. So what does that mean? We have to invalidate all the remainder of these 15 trials and do them over again. And they're making the point here, like, we got to settle this, right? Let's not put good money after bad. Let's figure this out now before we have to rebuild all this again. Saying it's neither prudent nor efficient to require the courts, the parties, or the taxpayers to run the significant and the avoidable risk of having to go through this painful and divisive and this expensive process more than once when an existing structural error can be remedied by this court right now. We can just pause this whole thing and allow the court to make a decision on this, and then we can decide if Fani stays. Great, Fani stays. The case can move forward. We can have our prosecution without worrying that she's corrupt and she should not be on it anymore. Now, this was the original RICO indictment, and I wanted to see when this was ultimately brought forward. Yeah, Fani Willis signed off on this. So this is the original indictment that came out. And I noticed this. So this was filed August 14, 2023. So this was kind of stuck in my craw as we were reading through this filing, because I thought Steve Sadow said that the filing started in 2023. So that's, I think, a typo, right? Please correct me if I'm wrong on that. But that was stuck in my craw for a minute. So I thought it was filed in 2023. So please correct me if I'm wrong on that. But I think that is a year off. So could be wrong. But those are the two documents we've got. So let's keep that in mind. Now, that being said, it doesn't deviate from the point that we're making here. If we have a perjuring Fani, we got a big problem for all of the trials. All right. Now, second, the need to establish precedent in this case regarding the disqualification standard for forensic misconduct is manifest. Right? Judge McAfee, we had a lot of time here battling about what's the standard. We talked about all this case law. Is this misconduct? Is that misconduct? Does it rise to the level? What's the standard? Is it a clear and convincing evidence standard? Is it preponderance of the evidence standard? And so on. We don't know. So, hey, Court of Appeals, you can help us with that. The trial court candidly acknowledged the lack of appellate guidance on this important disqualification issue. that significantly impacted his ruling. And in the forensic misconduct context, he noted there was no appellate guidance outside of Williams. Judge, I don't know what to do with this case. I don't know how to apply this misconduct standard. That his decision was unmoored from precedent, right? In other words, Fani didn't have any notice about this. He felt confined to the boundaries of Williams. And so, Court of Appeals, you can help clarify this so that other judges don't run into the same problem. Now, with additional and appropriate guidance from this court, Judge McAfee's ruling would come out differently if you gave us the right standard. And third, the trial court also expressly found that Big Fani's challenged actions that were including hiring her paramour, her boyfriend called Nathan, found that as the lead prosecutor in his matter, found that Willis was accepting gifts, was accepting trips that were funded through compensation and created by doing so an appearance of impropriety in this case that cast a pall over these entire proceedings. Now, the trial court was bound by existing case law to not only require Wade's disqualification, which did occur, so the judge got that right. Okay, there's an appearance of impropriety here at least, so one of you has to go. But also, right, if he's going to find that Nathan's bad, also Willis has to go, and as a result, the entire office. Now, the trial court's failure to do so is plain legal error, McAfee, that requires reversal. And before we get into the nuts and bolts of how this works, they say, here's another reason why you should accept this appeal. Finally, the public's faith in the integrity of the judicial system, especially the criminal justice system, is critical to its functioning. And I know we talk about this and it feels like a platitude here. It's like, I say here like a broken record, legitimacy, credibility, legitimacy, right? And why what they're doing is such a problem is because it's wrecking that, right? Nobody has any belief that the FBI, for example, is telling the truth about anything. Okay, all right. Well, the FBI said it wasn't terrorism. We're like, oh, okay. So who was it? Who was the terrorist then? Right? We all just don't, because they've done that to themselves by politicizing the industry, say the entire, bureau. Same thing that's happening with the DOJ and Merrick Garland and the judiciary, the judges who are showing up to hang out with Caitlin Collins on CNN and rant about, being under threat from J6ers, whatever. So when you undermine this, it wrecks everything. And there's not much coming back from this, right? The judiciary has been built over 234 years until they decided to abuse it, and it's on its way out. It's like on fire as we speak. Now, courts have an obligation, and McAfee has not helped with that, by the way. Courts have an obligation he poured gasoline there in Fulton County. All right, Rob, continue. Courts have an obligation to ensure that the legal proceedings appear fair to all who observe them. Or not, or whatever. You can lie, just one of you has to go. When the public perception of the integrity of the criminal justice system is at stake, no prejudice to the defendants needs to be shown. The fact that we all know this is corrupt is enough. Now, nowhere are these interests more important or on display than in a high-profile case like this one that has captured the attention of the nation. Crucial to the public's confidence is that prosecutors, like Fani, remain and appear to be disinterested, and impartial. A Supreme Court case called Berger says the prosecutor is, quote, a sovereignty whose obligation is to govern impartially, is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but instead that justice shall be done. Now, the prosecutor has more control over life, liberty, and reputation than any other person in America. And so that's why when Fani goes ranting at her church about racist white people, MAGA Trumpers, or whatever her keynote there was about, that's a problem. Because not only do they have the power of the prosecutorial badge, but they also have the power of the public sphere, the arena, right? The bully pulpit of the office, which is a very powerful position. We see it's even maybe more powerful than the Superior Court there in Georgia, in Fulton. So prosecutors are supposed to swear to take a higher oath a higher obligation. And what we've been seeing out of Alvin Bragg, out of Fani Willis, out of Letitia James, and out of Jack Smith is the opposite of that. Now, to avoid structural error, this is Trump's defense and the co-defendants appealing. They say, to avoid a structural error, meaning the prosecutor is corrupt, so like the chair falls over, it would invalidate and it would require a repeat of all of the upcoming trials. And it would establish, if you accept this appeal, needed precedent in an area of disqualifying forensic misconduct, so we have better standards moving forward. And it would also protect and maintain the public's confidence in the integrity of our justice system, because it would at least show us that a second set of eyes, at least the Court of Appeals, has taken a look at McAfee's terrible decision. So here's some background for us. All right, Court of Appeals, in case you missed America's most recent saga, they give us some background. They say, all right, on January 8th, defendant Michael Roman, via Ashley Merchant, filed a motion trying to disqualify Big Fani and her office based on the personal financial stake that she had in an improper and a secret relationship with her lead prosecutor and lover and boyfriend, Nathan Wade. Now, the Roman motion alleged that Fani hired Nathan and paid him about $650K, in a 2-year period, and that was personally financially benefiting from the relationship, among other things. Now, the evidence revealed that within the 7-month period from October 2022 until April 2023, Wade incurred over 17 G's. We'll use Fani's language here. You know, if I owe a G, it's 1,000, right? So 17 G's in credit cards for vacations that he and Big Fani took to Miami, to Aruba, to the Bahamas, and to California in Napa Valley, where they went around on wine tours. Now, Fani was also admittedly the recipient of day trips to Tennessee, to Alabama, to South Carolina, North Carolina, other ports of Georgia, numerous lunches and dinners. And these expenses were not only shared proportionally or even tracked. They didn't keep track of that. They paid with cash. Now, indeed, Willis could only provide a single receipt for 2 plane tickets that totaled $1,300 to offset the more than $17,000 that were paid in benefits by Wade. And long before the Roman motion was filed by Ashley Merchant, Fani had already engaged in a conduct that was designed to prejudice the defense. Fani began by repeatedly making widely publicized and improper extrajudicial statements throughout the course of the investigation, which clearly is in violation of her heightened ethical obligations as a prosecutor. Not supposed to do that. She's out there running her mouth in church, going to the media. The Fani train is coming. She's still doing it. She was out there after the judge decided to keep her on the case. She's like, I'm the face of women now. I can't believe I'm such a role model for women. I had no idea. We're all sitting going, what? She's the face of feminism now. Yeah. Get elected to a government position, hire your boyfriend, pay him $650,000 over 2 years, go on multiple vacations with him. Don't tell anybody about it. Lie on your disclosure forms. Have him lie on his interrogatories when he is getting married or getting divorced. And then when you're asked about it in court, lie again. Commit a felony, perjury, when you're the DA of the entire county. Role model for women. You can do it too, young ladies at home. Work hard. You can be just like Big Fani. So in spite of, or perhaps because of, the defense says, of the impending hearing on the motion to dismiss and to disqualify because they knew this train was coming, Fani undertook significant efforts designed to prejudice the defense and to deflect attention away from her, and otherwise to conceal the full nature of her disqualifying behavior. On January 14th, Big Fani, only 6 days after the Roman motion was filed, blowing the lid off this whole thing, we were going, what? Fani, reading from prepared notes, gave a speech at the Big Bethel Church, which is a historical black church in Atlanta, which was televised all across the world. And in that speech, Fani, while concealing her personal relationship with Wade, she improperly injected race and racial bias into this case. She was up there at the podium. Why, God? Why are they bringing their scrutiny down on me and a black man? And we said, what? That's because you slept with him. Fani, obviously. That's like the obvious answer. What's your next question? Give us something harder. And she lied about paying them the same amount, right? She's, oh, no, they all get paid the same. It's all. No. The guy who wrote the book on RICO was getting $150 an hour to Nathan Wade's $250. And that got spread all over the place, indicating that the defendants and their counsel were racist for challenging her unethical conduct. Racism, clearly. And that they were guilty and that they were going to be convicted by her superstar team. And my superstar team has a conviction rate of 95%. And all we do is win, baby. Win, win, win. No matter what. Pass me the Grey Goose. Implying that God himself had chosen her for this case. God is looking down upon her. And if you oppose her, well, I guess clearly you oppose God. See you in hell, defendants. Now, that he was on her side and that she was doing his work in the prosecution. It's like sick, right? So approximately 2 weeks later, and she has prosecutorial power. And apparently the people in Fulton County are going to re-elect her. I guess they love her. So approximately 2 weeks later, then this other company called the Hatchet Book Group, they published a book about Fani and the ongoing criminal case. They put her out there as this, quote, hard-charging, afraid of nothing prosecutor. And she did. She's pretty hard charging. She busted into that courtroom like the Kool-Aid guy. Oh yeah, let me testify. Give me my glasses, my water, and my documents. Oh, huh? According to the authors, Willis gave them, quote, significant access and time. And Willis certainly knew that this book would be published prior to the trial in this case. And if you read the book, which I've not read and don't recommend, in her extensive interviews with the book's authors, Fani continued to thrust, they did that intentionally, didn't they? Steve, you did that on purpose. We know you did, didn't you? D.A. Willis continued to thrust her themes. I'm sure she did. Yeah, I'm sure she did. That should be the standard moving forward. How many puns can we insert into our court filings? Yeah, Fani was thrusting all right. She was thrusting her themes of alleged racism against her into her book, thrusting repeatedly, and her office into the public forefront, providing details of racist comments and threats of violence against her. I know, she's always under attack, as well as highlighting her need for enhanced security. Among other things, Willis told the authors that since her office had opened this case, the comments were always racist. Everything's racist all the time, nonstop, every day. Somebody just said good morning to you. She's like, well, it's not, it's a Thursday, that's bigoted. She again invoked God as her ally, stating that she had God's protection and his direction in handling this case. So she's blessed by God to go after Trump. All right. So that's Fani. Now, having already significantly compromised the defense and their due process rights, Fani then began her efforts to conceal the full nature of her behavior from the trial court. This is the cover-up now, right? And the cover-up is way worse than the underlying crime. Like the underlying crime was already problematic. And okay, but maybe it's not material. Maybe there's nothing, whatever to it. And it starts coming out and they lie about the misconduct. You go, whoa. You sign documents now that are clearly lies. You have witnesses that are showing you're clearly lying. And then you have guys who are petrified on the stand. They change their stories. They're talking differently to other prosecutors in other county. I'm talking about Terrence Bradley, who said to a different prosecutor, was there when Fani called and said, basically, shut your mouth. So on January 17, 2024, not long ago, Fani, through her private lawyer, filed for a protective order in Nathan Wade's divorce. We remember that. We read it. In that filing, Willis accused Wade's spouse, Jocelyn, innocent, nice woman, of conspiring with interested parties. Fani says Wade's ex-wife is conspiring to interfere in this case and to use the civil discovery process to embarrass Big Fani. And that sounds like an insurrection, right? That is an implied threat of prosecution by the DA. And Judge McAfee's like just totally cool with all this going on. He's like, well, somebody else can deal with it. I guess the state bar will look at it. I mean, there's an odor in here. Maybe someone else can address that. I really don't like how it stinks in here, but I don't want to do anything about it. So on February 2nd, Fani filed an opposition to various motions to dismiss and disqualify. So it included an affidavit from Wade falsely claiming that they did not begin their personal relationship until 2022, which was after the appointment, which is why that date matters, and before the indictment. So Nathan Wade got appointed, remember, on 11/1, November 1st, and then he divorced Jocelyn on the 2nd. Nice guy. Hey, got my contract with Big Fani. Yeah. So then tells his wife, I'm out of here. So long, sister. I'm out. And the state's opposition came in after that. Now, at the evidentiary hearing, which we spent some time on, February 15th, both Fani and Wade similarly testified under oath that their romantic relationship began around April, early 2022. But the evidence at the hearing, however, demonstrated otherwise. For example, the defense presented testimony of Miss Robin Yurdy, who seemed very credible to us, and said this woman was a former friend and an employee of D.A. Willis, who testified that Willis's romantic relationship with Wade started in 2019 and that there was no doubt that it began before Wade was hired, right? Lie. Sorry, Fani, we have an actual witness who says they lied. Clearly started in 2019 at the CLE at the judicial conference when they had their robes on. They had their gavels around. They were like, I hereby sentence you to whatever. And they're like, and that there was no doubt it began earlier. Now, Miss Yurdy's testimony was corroborated. That was sent to Roman's defense attorney called Ashley by Terrence Bradley. Terrence Bradley was Wade's friend, longtime personal friend, who told Ashley, yeah, it started a long time ago. And he was also Wade's former law partner. He confirmed that the romantic relationship between Willis and Wade had absolutely started when Willis was a judge in South Fulton. They had their gavels, which was in 2019, of course. Now, the evidence was further corroborated by the analysis of Wade's cell phone records, where he's making Fani calls late night riding over there, which proved that his phone was in the immediate area of her apartment on at least 35 occasions, including at least 2 overnight visits. The 11 months of available phone records that came before they said that they were indicting each other proved that during that period, Willis and Wade, they claimed that they were friends. Wrong, that there were over 2,000 phone calls when they were just friends, and there were just under 10,000 text messages, 9,700 text messages between the two of them, for an average of 6.2 calls and 29.3 text messages per day. Oh my gosh. They did the math on that. These exact numbers were included in a non-public filing as an attachment. So we didn't see that before. So they did the math on that. 6 calls a day? Holy moly. I would be so irritated. Like, what? What else do you need? I talked to you like an hour ago. I just had lunch. I just told you what I ate. No, I'm not doing anything else now. Literally the same thing an hour ago that I'm working on. Can you leave me alone for the love of God, Fani? She's calling him, right? She's like, just, hey, what are you doing? Hey, I'm just thinking about you. What are you doing? Anyway, so it's ridiculous. That's insane. That's an insane number of phone calls, okay? That's too many phone calls per day. And 30 text messages per day? How many is that per hour? Ridiculous. Dude. Have some boundaries on your life. Golly. No wonder he's so happy he's off this case. Nathan Wade's like fired. He's gone. Are you kidding me? He's like, this is the best thing that ever happened to me. She was calling me. He was talking to Terrence. He's like, dude, she calls me every 45 minutes. He's like, you're kidding me. Look, he's like, look at my phone records. Look, it's crazy. He's like, dude, that's crazy. She's like a stage 5 clinger. He's like, I know. I can't get rid of her. I know. Just go public with your affair. Just leak it to the press. Tell Ashley Merchant. Maybe that's what happened. This whole thing is Nathan Wade just trying to escape. He leaked it to Terrence Bradley. He told Terrence Bradley to leak it to Ashley Merchant so this whole thing could escape so he'd get fired. That's what happened, isn't it? And we just figured it out. All right, furthermore, all right, back to Realityville. Furthermore, Fani Willis and Nathan Wade, this is the appeal from Trump's defense, saying Fani is really somebody who needs to be off this case. They both came into court and they testified to a wholly unsupported explanation of cash repayments. No idea where that came from. Without any documentation of payments or the source of the funds, despite the fact that they're both, lawyers, apparently, and the fact that Fani, as an elected constitutional officer, has strict reporting requirements that require her to keep track of any expenditures on her behalf that exceed $100 in any given year. But she said that they weren't a gift, right? In fact, in her disclosures for 2021 and 22, Fani certified that she had received no gifts or benefits in the yearly aggregate of $100. Even though the undisputed evidence shows that she received the benefits of thousands of dollars of Wade, who was even listed in there as a prohibited source. So she knew, right? Clearly lying, covering this up. Like, they're not idiots. I mean, they are, but you know what I mean? Like, they knew that she put it, when she signed off on that document, she skipped right over that one. No one will ever find out. Now, the trial court criticized Scott McAfee, criticized Fani and her conduct during the testifying and her testimony at the hearing. He called her testimony unprofessional. He said that her overall conduct was, quote, a tremendous lapse in judgment. He said that there is an odor of mendacity that lingers. And it's going to continue to linger. I mean, I guess, unless all of the odor was with Nathan, and he's not there anymore. So if it's still lingering around, it must be coming from Fani. So why is she still in the case? The trial court labeled the cash repayments as unusual. And the lack of supporting documentation is, quote, understandably concerning. And then he said, but I still love Big Fani. Big Fani for life, Big Fani 2024. The trial court then went further, characterizing it as a, quote, financial cloud of impropriety, stopping just short of calling her testimony about these so-called cash payments an outright fabrication. Didn't say that. The trial court half-heartedly said that her testimony on this issue was, quote, not so incredible as to be inherently unbelievable. It was not so incredible as to be inherently unbelievable, which is like, okay, Judge. If you believe that Fani paid him back 50-50 on all of those transactions, I don't know what else to say. But the trial court gave DA Willis no such benefit of the doubt regarding the untruthfulness of her testimony about when the relationship started, because he described it as potential untruthfulness about that, which was a direct lie. Now, the trial court also noted that, quote, there are reasonable questions about whether Fani and Nathan testified untruthfully about the timing of their relationship, and that potential untruthfulness further underpins the finding of an appearance of impropriety and the need, if it is actually improper, to make proportional efforts to cure that. Saying, now, despite the damning findings that there was a significant appearance of impropriety, and instead of disqualifying Fani, the trial court then punted. They punted Fani's numerous legal and ethical violations to other people. Other people can handle this. To other forums and sources of authority, like the General Assembly, like the Georgia State Ethics Commission, like the Georgia Bar, like the Fulton County Board of Commissioners, which I think they said we don't even have jurisdiction. And to the voters of Fulton County, I'm not going to interfere with democracy, and that they could offer feedback on any unanswered questions that linger from that stinky owner of Fani's taint. Which Judge McAfee is allowing it to happen in his courtroom. He goes through all of that, and then the guy who goes on, news interviews and podcasts and says that he wants to adhere to justice so that he can look his kids in the eye, or whatever that stupid little talking point campaign speech was, then just eats it right in his face. But she can stay on the case and her prosecutors can be back in there as they were yesterday. So inexplicably, the trial court then permitted Fani, the very person whose actions created the appearance of impropriety, whose explanation was not quite inherently unbelievable, whose testimony still harbors the question of being untruthful, who falsely claimed that she was not talking about the defendants in this case, who also created the lingering odor of mendacity. The woman who has been responsible for all of that, the judge somehow is going to decide to cure the Fani and the significant appearance of impropriety that infects the current structure of the team. And he's going to attempt to purge this case to air out the noxious odor and the appearance of impropriety and the lingering stench of lying and falsehoods in Fani and Wade's testimony. He's just going to try to air it out, de-stinkify it, Febreze all over the place. Not going to work. Now, and unsurprisingly, the choice made by Fani was for Nathan to resign. She's like, later, dude. See you later. Pfft. And again, he's out of there. He's like, it's been really great working with you, but I'm going to take my $700,000 and good luck. See you later. Now, hopefully there's no recriminations and there's no restitution and he's just off scot-free. So thus the case carries forward with Fani still in charge, regardless of the continuing appearance of impropriety that the judge already described. She is there, her office remain involved, the case and the taint remains. So we appealed this, they say. On March 15th, the trial court entered an order, and that order contains a number of legal errors, and so the Court of Appeals in Georgia should accept this and rule accordingly. They say, here are some problems. First of all, Scott McAfee granted the defense motion in part and made 4 determinations. So they're saying this is what McAfee did in his order. They say, first, Fani does not have, this was a finding, an actual conflict of interest in this case through her personal relationship and her travels. That was number 1, first finding. Now, number 2, second, however, there is a significant appearance of impropriety that infects the case and the current structure of the prosecution team. And the appearance needs to be removed. What happens? 1, Fani can go and her whole office can go. She didn't do that. Alternatively, Wade can go, and we know that's what happened. Now, number 3, the order denied Trump's and the defense motion to disqualify Fani, saying that it was unmoored from precedent to do so, saying we don't have a background of throwing somebody off for this type of conduct, and so Fani has to stay. And fourth, and finally, the order determined that Willis's appointment of Wade did not violate Georgia law, and so it could continue on. And so the court timely issued a certificate of immediate review authorizing this to go up to the Court of Appeals, and that's where we are now. Now they say, what is the standard for appealing this? Here, as a matter of law, the Court of Appeals needs to correct the record below, saying as a matter of law, Fani Willis's, the Big Fani's disqualification was required as a matter of law, and McAfee erred by not ordering it. And so you should be reviewing this and vacate the lower court judgment. Here's the argument. They say the Georgia Court of Appeals say you can accept this appeal for an interlocutory review if any of these things are true. 1, the issue to be decided appears to be dispositive of the case, right? So if Fani is disqualified, does this case go away? The answer is maybe on that. Like, actually, yes, it could go away. Or the order, like, it's going to settle the case. If we can settle it, let's settle it. The order appears to be erroneous and will probably cause a substantial error at the trial, which would mean a trial would be prosecuted by a corrupt prosecutor like Fani, and it would adversely impact the rights of the people who are there, or the establishment of precedent is desirable, right? And so I think, like, all of these are good factors. If any of these exist, the Court of Appeals should accept this case, Well, if Fani's disqualified, it might be the end of the case, right? We don't know if another prosecutor will take it or not. So that one's kind of a maybe. If Fani stays, the case will stay on and go. But if Fani goes, it might be the end of it. So maybe on that one. The order appears to be erroneous. They got some clear understanding of that. And if Trump goes to trial with a corrupt prosecutor, there will be a problem there. And we don't know what the standard was, so we do need precedent set. So basically 3 for 3, I think those are all very favorable for the appeal, why the Court of Appeal should accept this. They say, here the application easily satisfies the second and the third criteria. The first one is the 50-50 one, right? Whether it's dispositive or not. And while disqualification is not dispositive of the underlying allegations, failure to disqualify would require a reversal of any judgment that she got. Right? So it would have to come back down again. We'd have to do this over again. Now, the application here, we get into some of the meat and potatoes of the application for the appeal. They say we should grant this because the erroneous failing to disqualify Fani creates a structural error. It's like trying to play with the cheater who you know is a cheater who's continuing to cheat in the game. It's like playing chess against somebody and they're getting, the scoreboard and directions from somebody else. You're not going to continue to play against that person because you know that the outcome of the game is going to be rigged and tainted. So they say the failure to disqualify a prosecutor is a structural error, and structural errors require review. Courts have a duty to ensure that the accused are afforded due process of law, and that means a fair trial. Trial courts must take strong measures to ensure that the balance of the factors is never weighed against the accused, and the Supreme Court has determined that due process can be violated when there is negative pretrial publicity, when it's widespread throughout the media, television, and so on. And so the failure to disqualify Fani in this case is a structural error, and we have a right to due process. They have a quote from Fani in here. This is amazing. Well done. Here is a quote from Fani they start Section B with. This is Section B. It's called, "The application should be granted to provide this court with an opportunity to set a standard," right? What is forensic misconduct, and when do we disqualify the prosecutor accordingly under that standard? Here's the quote from Fani that starts this section off. She said this November 14, 2023. Apparently it's on YouTube at that link. Fani said, quote, "If I were to comment on any open case, it would be a reason to conflict my office out." That's true, Fani. Yeah, you got it right there in November. So the trial court, for some reason, explicitly found Scott McAfee in its March 15th order that Fani Willis and her extrajudicial statements made on January 14th were legally improper. In its order, McAfee deferred Willis's legal and ethical violations to other forums, like a total weenie. He said, well, the Ethics Commission can look into this. The State Bar can look into this. How about the Fulton County Bar? Whatever. Because he's so weak, he didn't want to do it himself, even though they lied to his face in his courtroom. It's wild. It's like, can't even look at him the same. It's like, really? But this cannot be squared with Scott McAfee's finding that the courts have an independent interest in ensuring that criminal trials are conducted with ethical standards of the profession, and legal proceedings appear fair to all who observe them. Yeah, it's like, look, if Scott McAfee's at a party, all right, and Fani Willis tells him a lie, a big fat whopper of a lie, I'm like, okay, Fani, yeah, I'm sure you hiked up to the top of that mountain. I'm sure you did. Oh, really? Yeah. You do it all the time. Okay. What mountain? Okay. All right, sure. So that's not a big deal. Okay. It's a little white lie. She probably says it all the time. You can laugh at her. Oh, I'm sure you do. You look great. Yeah, I'm sure. Yeah, we'll do it sometime together. I'm sure. So that clearly is not, consequential to the functionality of the law. Now, when she's in your courtroom and lies to your face, you have questions about how she handles the rest of the trial and whether she's being truthful or honest as the case unfolds. So that's why he's got an obligation to do something about it and not outsource it to other entities. So The trial court also expressly found that there are reasonable questions, Scott McAfee, reasonable questions about whether the DA and her hand-selected lead, Wade, whether they even testified truthfully. McAfee said, yeah, there's an odor of mendacity that lingers in this case. And despite the findings, the trial court applied Williams versus State, our Supreme Court's decision on this type of stuff. It felt confined to stop short of disqualification due to a professed lack of guidance in Georgia law. He said, well, I didn't know what to do about this. I don't know what the standards are when to disqualify a prosecutor for forensic misconduct. McAfee wrote, the court has not located nor been provided with a single additional case exploring the relevant standard for this misconduct. How do we measure it? Or an opinion that actually resulted in the disqualification under Georgia law. Left unexplored, therefore, is how other examples of forensic misconduct can manifest, such as whether statements that stop short of commenting on the guilt can be disqualifying. Nor has it been decided if some other showing of prejudice is required and how a trial court should go about determining whether the prejudice exists. Nor, right, this is McAfee, I don't know what to do. No one's never done this before. Help me. Nor is it clear whether the analysis differs depending on the pretrial posture of the case, whether that's before a conviction or after. So unmoored from precedent, the court feels confined to the boundaries of Williams. So since no one else told me what to do, I'm just going to follow Williams, and restricts the application of the facts found here to its limited holding. Weak. So in Williams, the Georgia Supreme Court articulated a standard that was to be applied in Georgia for disqualifying forensic misconduct based on a prosecutor's pre-trial extrajudicial statements expressing a belief in the defendant's guilt. So they say, well, this is what happens in Williams, okay? So McAfee says, I didn't know what to do. I couldn't find any guidance on this, so I referred to Williams. They say, oh, you did. Well, here's what Williams says. In determining whether an improper statement of the prosecutor as to the defendant's guilt, so think about a Fani and a Trump, whether it requires disqualification, here's a standard. The courts have taken into consideration, quote, whether such remarks were part of a calculated plan, evincing a design to prejudice the defendant in the minds of the jurors, and whether such remarks were inadvertent, albeit improper utterances. All right? Wow. So that's a pretty good standard. So what if we applied that to Fani? Do you think Fani's pre-prepared notes that she wrote out for a speech at church, do you think that was a calculated plan? Yeah, obviously, they were a prepared speech. She went out and gave them at a church. Do you think it was designed to prejudice the defense in the minds of the jurors? Of course. It's her whole constituency in Fulton County. There are jurors in there who would get a letter to report for jury duty. She was trying to prejudice them because it's race. She called them racists and demons, essentially, who were oppositional to God. So all of it was not inadvertent. It wasn't speaking off the cuff. It was all prepared. That's a pretty dang good standard. What's so complicated about that, Judge McAfee? Now, as the passage of the order quoted above makes clear, the trial court felt constrained to limit its application of Williams to its particular facts. Williams only applies to Williams because of the lack of Georgia legal precedent addressing forensic misconduct that does not involve prosecutors expressing their belief in a defendant's guilt. Now, in footnote 7, they give us some more background on this. They tell us that the trial court was obviously concerned in its order about the lack of appellate court guidance, which is why we're here appealing. But the absence of precedent involving circumstances similar to those in this case is hardly surprising, right? There's no wonder there's no precedent here, because this is insane. No prosecutor has ever been so reckless in a relentless pursuit of personal gain that she provided endless pretrial interviews to the media, granted unprecedented pretrial access to the authors of a book, or attempted to distract from her disqualifying and unethical behavior by publicly and wrongfully castigating the defense as racist and proclaiming God to be having anointed her and to be on her side. But the fact that no case of such outrageous prosecutorial misconduct has ever occurred before and cannot does not mean that the Williams standard is not satisfied. And furthermore, Williams did not purport to enumerate all potential examples of forensic misconduct, which would support the disqualification of a prosecutor either. Saying if this outrageous and unlawful and unethical conduct does not satisfy that standard, well, then the forensic misconduct standard does not, in fact, exist in Georgia. If this is not misconduct, then we don't know what misconduct is. Like literally, like if Fani can get into court and lie to you and steal 700 grand and appoint her boyfriend, and then nobody does anything, and the judge is like, well, we'll see if the bar will look into this. What? Okay, I guess there is no misconduct. So Fani can like do basically whatever she wants because no one's going to do anything about it. McAfee is on appeal. This is the defense writing, saying by its own terms, the Williams case should not be read in such a limited fashion like McAfee did. Instead, the Williams court noted that the type of forensic misconduct that it addressed in that case was an extrajudicial pretrial comment by a prosecutor on the defendant's guilt, but that one of the primary examples of forensic misconduct was that. It wasn't the only type of forensic misconduct. It was just one of the examples. The court cited to a law review article from Columbia that broadly defines prosecutorial misconduct as any activity by the prosecutor which tends to divert the jury from making its determination of guilt or innocence by weighing the legally admitted evidence in a manner prescribed by law. So you have legal evidence that comes in. That's why we have objections. Relevant, right? Relevancy. Not relevant. We keep it out. So when Fani goes out there and calls them racists and demons, that diverts the jury away. That's in the Williams case. Some footnotes here. They say the court cannot find that the speech crossed the line. Now, the trial court, McAfee, ignored one of the arguments that was made by Willis in the church speech that did, in fact, comment on the guilt or the innocence of the defense. So McAfee said, well, she wasn't commenting on the defendants or their innocence or guilt. And they say, yeah, she did. Now, it's very cute that he found that it didn't, like he read it that way. But Willis twice referred to a 95 or 96% conviction rate for her office. So in the context in which these statements were made, it is clear that she was professing a belief as to the guilt of the defendants, right? She's calling them a racist, and she's saying she's on the right side of God, but maybe not that they're guilty. But she says we do 95, 96%. Thus, even under their constrained reading, Scott's constrained reading of Williams, Fani should have been disqualified for forensic misconduct, and it legally erred by not doing so. She was clearly talking about the defense. She was clearly talking about their innocence or guilt, in this case, guilt. And that enough is alone, even under the Williams standard. So the appeal continues, saying also the full text of this is the full quote from the law review article, so we'll fast forward through that. But the actual standard for disqualifying pre-trial forensic misconduct, so before a conviction happens, and the broader but necessary application of the principles set out in Williams is logical. We also have Supreme Court precedent about due process. We also have strict prohibitions on prosecutorial public statements in the ethical rules. So it simply cannot be the case that anything a prosecutor says is fair game. There are rules all over the place that prohibit this. A prosecutor appearing on a national television show to malign and to disparage defendants is not rendered consistent with due process or her ethical obligations merely because she refrains from explicitly saying that they're guilty and only strongly intimates it, like she has to say, I think they're guilty, and only then it's a problem. The existing due process and the ethical guardrails already in place extend well beyond simply protecting a defendant from a prosecutor's pretrial comment on his or her guilt. But because of its admitted uncertainty caused by the lack of the appellate court guidance, the trial court McAfee felt compelled to apply Williams very narrowly, saying, and by doing that, there is substantial doubt expressed by the trial court in its order that the ruling's correct. And so that's why the Court of Appeals, we need some precedent on this. Now, the appeal from the defense continues, saying Willis's extrajudicial statements are disqualifying. Says Williams, the case that McAfee relied on, instructed that courts must look as to whether statements were made as part of a calculated plan. Clearly they were. Willis's statements and conduct demonstrate a design to prejudice the defense. Here, while many of Willis's statements during this case are alone sufficient misconduct to warrant her disqualification, there are even more. Throughout this investigation and case, Willis has provided numerous interviews to the media, which she called the acts under investigation criminal and illegal. She discussed the mens rea of the accused, right? The mindset, the guilty mind. And she stated that the accused were facing prison sentences. She also gave significant time and exclusive access to the book called Find Me the Votes, knowing full well that it was all going to be released before the defense has their day in court. One in particular stands out. The DA prepared the speech to the church, the historical black church in Atlanta. The trial court said in these public and televised statements, this is McAfee, says Fani complained that a Fulton County commissioner and, quote, so many others questioned her decision to hire Wade. When referring to her detractors throughout the speech, Fani frequently utilized the plural called they. Fani argues that the speech was not aimed at any of the defendants. Yeah, maybe so, but maybe not, says the judge. And therein lies the danger of public comment by prosecutors. By including a reference to so many others on the heels of Roman's motion, which instigated this, Fani left that open for the public to consider. But more at issue, McAfee says, instead of attributing the criticism to a criminal accused general aversion to being convicted and facing a prison sentence, Fani ascribed the effort as being motivated by playing the race card. She referred to Wade as the black man, while the other unchallenged DAs were labeled one white woman and one white man, who, to our knowledge, she did not sleep with. And Anna Cross, the other white woman, I think is gone now, so I think we haven't seen her back in a while. The effect of this speech was to cast racial aspersions at an indicted defendant's decision to file the motion. Wild, right? Now, under Williams, that church speech alone is disqualifying, says this appeal. Even if Williams were unclear, the Supreme Court has said this. The heightened public clamor resulting from radio and television coverage will inevitably result in prejudice, just like Fani wanted. And the fact that Willis has intentionally and publicly injected race and racial bias and religion into this case and any possible jury pool, it makes the disqualification of Fani and her office even more necessary and appropriate. Now, you remember, Fani also indicated that the defendants were guilty, and she said that they would be convicted. She boasted about her prosecutors and their credentials. She said, we got a superstar team. We got a conviction rate of 95%. We got one that wins and wins and wins. But the comments didn't stop there from Big Fani. She also indicated that God himself had spoken to her and had qualified her for this case like delusional, and that she was doing his work in this prosecution of a rigged case. Now, of course, if she's on God's side, that means everyone else is not. She said, God responds to me. Child, pray for those. They can't see what I've qualified. Wait, God, I'm going to slow down here. It's your hard-headed child, said Fani. I told you I don't want to pray for them. I am tired of being treated cruelly. Pray for them anyway, child. Pray for their hearts. Pray for their souls. I qualified you. I qualified your imperfect, flawed self. I saw you in every hour do my work and ignored the distractions. And that was from Schaefer's motion. Now, the full extent of Fani's statements will be fully briefed if you accept this appeal, and we can't wait to do that. Now, the U.S. Supreme Court said that discrimination on the basis of race, like what Fani did, is odious in all aspects, and it's especially pernicious in the administration of justice. reliance on racial or ethnic bias has no place in the justice system. And because the prosecutor is a representative of the state, it is especially damaging to our constitutional principles when the prosecutor introduces racial discrimination or bias into our jury system. DAs in their offices have been disqualified or recused from prosecutions for making prejudicial statements to the media in other cases. Here's some of them. And this was a problem in those cases. And so that is why Fani should be disqualified here. Now, the forensic misconduct in this case is not limited to her improper statements that evidence her opinions of guilt. They're not limited to her claims of being ordained by God himself to convict the defendants. They're not limited to Fani and her false disparagement of the defendants or their lawyers as racists for the transgression of bringing to light her indictments and her unethical conduct of her boyfriend. But instead, no. Fani, in a desperate bid to stave off her disqualification despite this misconduct, and despite her stake that's been acquired in this case, she engaged in even more additional and even more deeply troubling forensic misconduct indeed. She knowingly filed a false sworn affidavit of Nathan Wade as part of their response to our discovery motions. And she lied to the court under oath in her testimony before the trial court. So did Nathan Wade. Now, the trial court, McAfee, stopped short of making a finding about Willis's lie because he wanted to protect her office, because if Willis lied in this case, whoa, man, then that just means she's kind of a liar, doesn't it? And maybe she lied in a bunch of other cases, and maybe defense attorneys have questions about every other case that she's ever touched there. So the judge protected her, carved out, gerrymandered a little bit of a verdict so he didn't have to say anything about this, saying that the court is not under an obligation to ferry out every instance of dishonesty. It's like such a pathetic cop-out. The record shows that the DA prosecuting one of the highest profile cases in this country arguably gave untruthful testimony under oath in this case and committed perjury, says the court needs to address this behavior and disqualify her, right? That is necessary in order for the prosecution to have any believability or any credibility, any legitimacy behind it. But McAfee, such a weenie, didn't do it. Alarmingly, the evidence also demonstrates that even after being rebuked for her improper and unethical behavior in this case by both Judge McBurney in his July order and again by Judge McAfee in his March 15th order, and having already been disqualified because of her actual personal conflict of interest, Fani is still utterly unrepentant for her individual misconduct and that of Nathan Wade, which we've seen. She showed up, yes, CNN, and had a bunch of interviews. She's giving interviews. I can't believe I'm the face of feminism now. Women look at me like a role model. Yeah, it's true. Women of all colors, especially black women. She's a role model. Fani said that. I didn't say it. In his July 25th, 2022 order, McBurney said that Fani had an actual and untenable conflict. Now, instead of following Georgia law, which required the disqualification of Willis, McBurney took the unprecedented and unlawful step of carving out one of the targets of the investigation from the case, Lieutenant Governor Burt Jones. Now, despite the fact that the decision was contrary to Georgia law, McBurney refused to allow the defense to appeal it. And so you can still minimize this by determining Willis was disqualified, right? So you have kind of a conflict here because in another case, the judge, did the same thing. The judge didn't want to, make a hard decision there either. So the appeal continues from Sadow and the defendants. And when Fani, after this order came out, right, Fani is like doubling down. Nathan's gone. She says, I did nothing wrong. I'm an American hero. I'm the face of feminism now. And you're welcome, America. When asked by CNN on March 23rd if she needed to reclaim her reputation, we played this clip earlier in the week, Willis said, let's say it for the record. I'm not embarrassed by anything that I've done. While continuing to claim she'd done nothing illegal. She says, I guess my greatest crime is that I had a relationship with a man, but that's not something I find embarrassing in any way. Hasn't learned her lesson at all. And why should she? Judge McAfee basically did nothing to her. Yeah, nothing. Her boyfriend got $700,000 and they're probably still hanging out. So the defendants here, they maintain below that the dismissal is the truly appropriate remedy. Why? Because Fani Willis and her office cannot fully undo the damage they've already caused here in this case. But her disqualification is the minimum that must be done to remove the stain of her legally improper and plainly unethical conduct from the remainder of the case. And given her lack of acknowledgement or of any remorse whatsoever for her misconduct that has been separately denounced by 2 superior court judges, her disqualification is necessary to ensure that she cannot continue to violate her heightened ethical obligations as a prosecutor to further prejudice the defendants in this case. And the ABA standards say accordingly. Prosecutors have higher duties. They cannot be partisan, political, or personal. And Fani has already taken 2 bites of the apple at the expense of the defendants and their due process rights to a disinterested prosecutor and to a fair trial. And Fani must not get a 3rd bite at this. The rules say accordingly, courts have an independent interest in ensuring that criminal trials are conducted within the highest ethical standards of the profession. Georgia courts have not hesitated to step in and use their inherent authority to disqualify a state prosecutor when required. And consideration of the violation is an important part of the analysis. Saying, additionally, while all attorneys are officers of this court and all attorneys have a duty of candor to the court, prosecutors have more. They have a heightened duty of candor to the courts and other professional obligations. And here, the defendants submit that Fani Willis's untruthful testimony, which was done to protect her personal interests in this prosecution, over and at the expense of the case itself, is at the very least forensic misconduct. Now, the Georgia courts are not only empowered to disqualify Fani to ensure this trial will be conducted within the ethical standards of this profession, but in fact, they're obligated to do so to protect the integrity of the remaining proceedings and the constitutional rights of the defense. And as DA Willis has herself acknowledged, she said, when you represent citizens, you need to be beyond reproach. Can you believe that? Here, Fani has covered herself and her office in scandal and disrepute and taint, as she has squandered her credibility and repeatedly and flagrantly violated the heightened ethical standards demanded of her position. The evidence of her forensic misconduct is overwhelming, and accordingly, the disqualification is required. Now, the trial court in their decision to not disqualify her is a structural error. It violates the defendant's due process rights, and it seriously denigrates the public confidence in the integrity of our justice system. And the appeal continues, saying the order's failure to find an actual conflict and its proposed remedy is also an error. Saying, Court of Appeal, Scott McAfee also screwed up here. As noted, the erroneous failure to disqualify Fani, who already has a personal stake in the interest, is subject to automatic reversal. So that's clear. Now here, though, the trial court erred in not holding that Fani was operating under an actual conflict based on the facts that the court found itself. The court found that these things happened, and so if these things happened, that's a conflict. But the judge found differently. Additionally, the remedy that Scott McAfee imposed are unprecedented in Georgia, and they do nothing to remedy the actual improprieties that they actually found. And so the trial court, Scott, erred in declining to disqualify Fani based on her actual conflict of interest. The remedy is legally insufficient. They say Willis acquired a personal interest that requires and necessitates her disqualification. Here's how it works. A personal disqualifying interest that can arise from either an actual conflict or an appearance. Lawyers, the rules say, must avoid even the appearance of impropriety so that justice is not diminished. And where an actual conflict exists, this certainly requires disqualification. And just on the facts that were found by the trial court itself, an actual conflict exists. a big problem between her public duties and her private interests. The appeal says, Fani Willis hired her lover, her paramour, to be the lead prosecutor in this case and then paid him $650,000 to do it. Now, compounding this problem, Fani then directly benefited from hiring her lover. Now, the trial court also erroneously found that the amount in issue was between $12,000 to $15,000, but the record of evidence submitted to the court shows the amount is over $17,000. Now, either way, the amount is significant because it's more than 150 times greater than the $100 limiting threshold that are in the requirements of Fulton County. Wade paid for lavish vacations around the world. Wade was funded from the $650,000 that Willis paid him. Now, ostensibly, because they knew it was wrong and because they knew it was a conflict, Willis and Wade actively hid their romantic and their financial relationship from virtually everyone, the public, the defense, and the courts. And when questioned about these benefits, both Fani and Wade gave false testimony to the trial court in an attempt to cover up their tracks. And Fani compounded this. She filed 2 false certifications that she had received no gifts or no benefits that were over $100, even though Wade was literally listed on the form as a prohibited source. And the aggregate amounts far exceeded $100. $17,000 is a lot more than $100. Now, they covered their tracks. Willis, in doing all of that, she obviously allowed her private interest to overtake and compromise her public duties. That was an actual conflict of interest. But even if Willis was not actually conflicted, well, she should have been disqualified based on Scott McAfee's determination that she appeared to have a conflict based on the evidence. Criminal defendants have a fundamental right to have a disinterested prosecutor. So whenever a prosecutor's conduct creates at least an appearance of impropriety, that means the defense is denied their rights to a fair trial. And under those circumstances, when they're denied a right to a fair trial, they're entitled to a new one. So whether there is an actual conflict or whether there's an appearance of a conflict, the law requires, McAfee got it wrong, the law requires the disqualification. You can't cure it by getting rid of one of them. And so the trial court erred in determining that no actual conflict exists. Fani Willis, her office, and Wade, they are trustees and they're servants of the people. Indeed, as the Supreme Court has said, a trustee is entitled to something stricter than the morals of the marketplace. They're held to something stricter than that. In Georgia, not honesty alone, but the punctilio of honor, the most sensitive, is then the standard of behavior. As to this, there has developed a tradition that it unbending and inveterate. So the most basic rule is that no public agent or trustee shall have the opportunity or be led into the temptation to make a profit out of others entrusted to their care. Put another way, all public officers labor under every disability and prohibition imposed by the law, and they can't make financial gains. And so prosecutors are supposed to represent the public interest, and they're required to preserve the integrity of the criminal justice system. Not recently. And as such, and the Georgia Supreme Court has found, prosecutors have additional professional responsibilities, even more than other lawyers. And thus prosecutors must wield their formidable criminal enforcement powers in a rigorously disinterested fashion to preserve the public's faith in the fairness of the system. And criminal defendants have a constitutional right to a disinterested prosecutor as well. And Fani has failed to meet those obligations. As the trial court has found, Fani, in her actions, created a financial cloud of impropriety. Her conflict creates a stain on the judicial process, impairs the defense right to a fair proceeding, and requires her disqualification. And so prior to the disqualification motions, Fani also publicly stated in her filing pleadings, before this came out, she wrote this, that the prosecutor has a heightened duty of candor to the courts. DA Willis knows that she has that heightened duty. She put it in a filing, but she has repeatedly failed that duty. So her conflict creates a stain on the judicial process, impairs the defendant's right to a fair proceeding, and accordingly, it requires her disqualification here. And so based on the foregoing, Court of Appeals, the trial court, as a matter of law, erred in determining that Fani Willis did not have an actual conflict requiring her disqualification. They made a mistake. Georgia Court of Appeals have found that public officers cannot have financial gain at the benefit of the public, that a public trustee's duty is to act not just with honesty alone, but with honor of the most sensitive kind. And a prosecutor cannot acquire a personal interest or a stake in their convictions. All of that is a no-no. And so if the law means anything in Georgia, the trial court's actual findings here establish an actual conflict. Saying the trial court also erred for refusing to disqualify her. Says Georgia courts regularly disqualify private lawyers for simply an appearance or a possibility of a conflict. Happens all the time. When there's an appearance of impropriety, such as those the trial court found here, then disqualification must follow, as this court has found. This concept makes sense intuitively and in the context of existing law. If private lawyers are disqualified from representing their clients based on a finding of an appearance of impropriety, well, then so too are prosecutors, because prosecutors are held to an even higher standard. Right? It's like when your younger brother did something that was illegal to mom, he might get away with it, right? Because he's younger than you. But if you did that same thing, you're in big trouble. And I know that because I have two brothers, younger. So I'd be like, well, Eric did it. I'm like, I don't care what Eric did. You're the oldest brother. You know better. Like, and you know, you did know better. But if it's, so I guess my point is, if it's bad for the younger brother, then it's obviously bad for the older brother who should know better and has heightened responsibilities. Fani fell below even the lower brother standard. Even the younger brother was like, I would never do that. I'm not an idiot. Fani's like, I'm jumping in. Who are held to even higher professional standards. They're required by due process to be disinterested. She's clearly not. In Davenport versus State, for example, a defendant convicted of assaulting her husband on appeal was denied due process because the DA in the case had represented the husband during the divorce. Yeah. Now, this court agreed, said there was at least an appearance of impropriety there. And so that's a problem. That denied fundamental fairness in the case. And so the court ordered a new trial. Same thing in this case. The court held that a trial court also erred by not getting rid of a DA because the DA may not be compensated by means of a fee arrangement, which guarantees at least the appearance of a conflict of interest. Now, in this case, Battelle versus State, another defendant was convicted for murder. He argued on appeal that the DA should have disqualified himself because the victim's parent worked there. Supreme Court of Georgia began its analysis. They said a conflict of interest or the appearance of impropriety from a close personal relationship with the victim may be grounds for disqualification. And so based on the facts of that case, the court said that there was no evidence that there was a conflict. But it could be. But the fact remains that the appearance could be enough to disqualify somebody. And so what's important here, as the appeal concludes, is that Scott McAfee, the trial court, expressly found an appearance of impropriety existed. Says, yep, there it is. And based on that finding, Willis was required to be disqualified. That's it. Nothing in the law anywhere says that the remedy for an appearance of impropriety is disqualification of apparently one other lawyer, but not the other. That's not the case. Yet that is what McAfee did because he was so, such a weenie, he didn't want to make a hard decision. If Wade was apparently conflicted and he needed to be disqualified, as they found, then Willis necessarily was also conflicted and also must be disqualified. And because the trial court properly found that an appearance of impropriety existed as to both Willis and Wade, the law requires the disqualification of them both. Otherwise, the appearance of impropriety is not cured, and neither the public nor the accused can have the required confidence in the impartiality of the fairness of the criminal process. Saying the trial court, Scott McAfee, specifically determined that when the appearance of a conflict exists, only the affected prosecutor, be they elected or appointed, is affected and must be disqualified. And the court also found that both Willis and Wade were so affected here. So, which under Georgia law requires the disqualification of both. And so the trial court, instead of providing Willis with the option to simply remove Wade, provided them with the option to simply remove Wade, confounds logic and is contrary to Georgia law. And because DA Willis is disqualified, so too is her whole office. Goodbye, Fulton County. As the Georgia Supreme Court has made clear, when the elected DA is wholly disqualified from the case, the assistant DA, whose only power to prosecute a case is derived from the constitutional authority of the DA who appointed them, they have no authority to proceed. You all have to go. Citing this McLaughlin case, saying that case also emphasizes the fact that a prosecutor's actual or apparent conflict need not be monetary or disqualifying. There, a DA and her office were disqualified because the DA's daughter was a classmate of one of the victims. Thus, close personal friendships, familial relationships, other circumstances can give rise to disqualifying conflicts of interest, in addition to disqualification based on the financial conflicts of interest. Okay, so they write, in conclusion, for the within and the foregoing reasons, this court should grant the defense application and accept the interlocutory appeal. Very good filing here, copied to everyone, but look who's not on this list. Very curious, huh? So sending this to everybody, Fani got a copy, Adam Abate got a copy, Daisha Young, we saw yesterday, got a copy, F. McDonald Wakeford, John Wooten, Grant Rude, no Anna Cross on that list. Anna Cross is not on the game anymore. This is brought by Christopher Anelwitz and the rest of the co-defendants. So I think a very nice filing, and I like how they're essentially saying Judge McAfee just got it wrong, right? He found there was an appearance of impropriety, and the appearance of impropriety is enough, and she needs to go accordingly. And I think it was very well written, very well argued. There was that question I had about the start date. So I'm pretty sure that was a typo and that this actually started, the indictment was actually in 2023 because it was so compressed. But nonetheless, I think that it is exactly right? This case needs to be decided now, because if Fani is allowed to stay on this case, she is going to continue the taint. She's going to continue to stink up this entire trial with a noxious odor. And long story short, I'm very hopeful that the Court of Appeals here in Georgia accepts it. And I think that they will. I think that they did a nice job also laying out why the Court of Appeals should accept this. And I think that was here at I'm trying to find those 3 bullet points that they made, but basically 3 different reasons. This could be dispositive. We don't want this to come back again. And we need precedent that has been settled and established. And the Court of Appeals should accept this. We're hopeful that they do. I have my doubts now about the future of this case. I don't know if it's going to get reversed or anything. I mean, to me, it feels like McAfee got the order. Like there's something else. There's some other unseen force at play here. We're not just in the court of law. We all kind of hoped we were only in the court of law. We obviously clearly know that we're not only in the court of law. There's also a court of public opinion happening here, and a bunch of phone calls and political machinations that are happening behind the scenes. So is the Court of Appeals going to come back down and reverse McAfee and disqualify Fani and maybe save his seat, or allow him to not be the bad guy? Disqualify Fani. They do it, not McAfee. Maybe, maybe not. I could also see the Court of Appeals saying, now that we've established the standard moving forward, this will be the standard moving forward, but there was no clear error on McAfee's point, and so they'll let it stand, not retroactively, but moving forward. I could see an argument like that. So a good filing. And so shout out to Steve Sadow and the other defendants who assembled this and got this off. We'll see what the Court of Appeals in Georgia says, whether they will ultimately accept it or not. We see here from our friend Phil Holloway, who's also on YouTube now. He's got a great channel now. And he said this, from Georgia, they only need one judge to accept this, okay? It's going to be assigned to a 3-judge panel. It only requires one judge to agree to allow the appeal to proceed. That's from Phil Holloway on X at Phil Holloway ESQ. And my understanding was somebody else said that Fani Willis may have just spoken. Is she out there speaking at a church or something like that? Here is what this looks like. Apparently, Fani Willis was at some event. She speaks at the Women of the Shields Awards. So Fani Willis was out speaking on Friday. And here's what Fani had to say, a little 40-second clip here from her speech. Let's see what Fani had to say here. Get this volume going.
Recently, they tell me they don't like me to talk hard out here, always having to prove yourself 2 and 3 times. Recently, they tell me they don't like me to talk about race. Well, I'm going to talk about it anyway. Truth is, it's some challenges that come to being black. And I see so much.
That's fine if you talk about race. You can't talk about it calling co-defendants racists.
Greatness in this city that has so many great African-American leaders. And I appreciate all of the sacrifice that you all have had to make to be in these positions. So, Chief Meadows, thank you for your leadership. Thank you for having the intelligence to create an event like this where we recognize that you've had to go through a little more to serve.
All right, so that's more Fani. And my guess is she's accepting awards now because she's now the face of women in America. She's the role model for women. And so that's Fani. We're going to see what the Court of Appeals says, whether they accept this filing. We're certainly hopeful that they do. But we're going to be here continuing to cover all of the Fani Willis saga news, all the filings. We'll see what her office says, if this is accepted, what they say in response to it. But it is another one marked down in the disqualification battle. Fani's not out of the woods yet. We'll see what the Court of Appeals says. And the secondary battle that will be also following along is whether the Court of Appeals stays the underlying proceedings, right? Right now, while we're asking for permission to appeal, everything's moving forward. We just had a motions hearing with Scott McAfee and the other defendants. But if the appeal is accepted, well, the argument is that there cannot be underlying proceedings because that would involve Fani Willis. And if Fani Willis is a corrupt, lying perjurer, well, we don't want her involved in the underlying proceedings until we decide whether she is in fact allowed to be on the case. So we'll have that question as well, which means the likelihood that this case goes to trial this year is a long shot, We'll see if they can get it back on track, but very unlikely. So we're going to be here covering this one and all the other Trump trials. We got the Alvin Bragg case, which is geared up for trial on the 15th, and that one's getting spicy. Alvin Bragg just submitted a response to Trump, who was talking about Judge Juan Mercan's daughter, Lauren. So we'll be here covering that and all of the rest of the litigation, my friends. Thank you for joining us as we do. Grateful when you subscribe. Appreciate you liking this video. Thanks for inviting someone you know or love to come over here and join us so that they can see all of what's happening behind the scenes on these cases. Of course, we got some great links down in the description below. We'd love it if you became a member, joined us, supported our work, got access to our morning streams for our members only, for our Saturday streams, again for members, and our after parties at watchingthewatchers.locals.com. We'd love to see you back over there and back here on the next one. All right, my friends. Well, that is it for us on the day. A big appeal submitted in Georgia, and we're looking forward to seeing what some reaction is to that, which we'll get into next week. But now, on this amazing Good Friday, my friends, let's hear from you and let's see what you guys have to say about all of this from our friends on YouTube, from our friends on Rumble, our friends on Locals, and elsewhere. We got some amazing support here on the day, and let's see who is starting us off on the show. And we're very grateful for Michelle. What's up, Michelle? Michelle is our newest supporter on the YouTubes. Welcome aboard, Michelle. Great to see you. We'll see you tomorrow on our members only stream in the morning on Saturday. We got Ike's Girl, who is also joining us. Welcome to Ike's Girl. And let's see, where did my screen go? We got Ike's Girl is in the house, says, did you know the pilot of the Dolly was Ukrainian? No, I did not know that. If that's true, sounds like an interesting little additional fact there, isn't it? Thank you, Ike's Girl. Thanks for being a membo and sending that one in. Gordon B says, happy Easter weekend. Happy Easter weekend to you, Gordon. Hopefully you're doing something good. And pausing. Keep up the great work, Rob. Thank you, Gordon. Very nice to have you here. Thanks for being a membo and for saying that. Happy Easter to you. Happy Easter to you, my friends. I think Mama Govea is making a ham or something. It's going to be delicious. Whatever she makes, I'll eat it. Good to see you. We got Brian C. says, Rob, thanks for delivering to us an understanding of all the facts, not just the noise and the nonsense. Thank you, Brian, for saying that. Brian C. A membo in the house. 5th super chat on the live stream, too. Very nice to see you, Brian. Well, thanks for joining us as we go through it. I love going in. I love doing the deep dives. I love, going into this stuff. So the fact that you're here and joining along is just, it's a real treat. We got this one from Ryan Patrick, also on YouTube, stopping by to say, remind us all, very important reminder, smash that like button. Thank you, Ryan. Good to see you. Ryan Patrick's also on the tubes. We got Super Buff is here. Shared this link on X from this guy, Brian, says Clint Hickman burned 2020 ballots at his ranch. They threatened to take pensions if anyone talked. He gets laughed at. This is a Clint Hickman list link. Interesting. Thank you for saying that, sending that one in, Super Buff. Over on Rumble, shout out to our Rumble friends. Great to see our friends on Rumble. Super Buff, thank you for that. That's a link over to Brian Ferentz. Dan's over there. Lori's over there. What's up, dog? We got Janik, Neurodivergent. We got Little Galaxies over on Rumble. We got great Rumble chat, too. What's up, Brian? Thank you. We got Penelope H. Penelope H is in the house and sent this one in. Do you know the makeup of the appeals court? Will they be fair, or are they just another corrupt entity? It's a good question. Who knows? Who the heck knows? Again, I agree with the theme of this motion. It's like, if this is not misconduct, I don't know what is. So, and the fact that McAfee couldn't come to that conclusion leads me to believe there's some unforeseen force out there that we're not accounting for. Like, we can have all the filings, all the courts, all the legalese, but if you can have a judge write a decision for whatever you want. So, it just becomes academic at that point. So I don't know what the appeals court is, but you were kind of hopeful that McAfee would be middle of the road. Sandy is on Locals, says, I love members only times on Locals. It is low-key chat opportunity to engage with you and others about topics covered. It feels like sitting around a kitchen table talking. I totally agree with that, Sandy. Yeah, our members only streams are not like this exactly, right? Like, now is a lot more like presentation style. The others are a lot more conversational, and we kind of just bounce around. It's a little more organic, and we get to, dive off on, like, sometimes I have a whole list of things to talk about and we don't get to any of them because somebody brings something up and we're down a rabbit hole for an hour. So it's a lot of fun. And thanks, Sandy, for saying that and for being a part of it. Mark N. What's up, Mark N? Says no name on that recipe to show she paid for it. Probably talking about the receipt. Probably talking about Fani. Yeah, Fani had no evidence at all. She paid in cash, but I'm just a white guy, so what the heck do I know? Good to see you, Mark. Thanks for being a membo for 1 month in the house. Sandy's on Local, says, the USA needs a hero in our legal system or it is permanently defunct. The Supreme Court is the root cause of the damage. When they refused to hear the 2020 election case from Texas, they were like mom and dad saying, I won't punish you for 4 years. Our problems are now their fault. Yeah, I think there's truth to that. It added to the lack of credibility. It added to the lack of legitimacy. Now all of us have had 4 years to just stew and say this is all illegitimate. And you know what? The evidence has come out to support our claim more now than then. There's more evidence now to say, oh yeah, they did rig it. Oh yeah, you got guys like Michael Morelli from the CIA saying, yeah, I just don't like Trump and just like Joe. That's why I did it. Oh. They could have clarified that. Leanne says a thrusting Kool-Aid climax. Oh, geez. There's taint written all over it. I'm hiding behind my couch right now, says Leanne. Yeah, there was a lot of that today. Yeah, and I think that should be part of the new strategy for the defense. See how many monikers, what's the word, euphemisms for intercourse that they can put into their motions. Thrusting, jousting, like things like, like bouncing, whatever, you know the list of the words, and just put them all in the motion. We'll pause there. Roger Needham says, you're just mad because the train won't stop. I think probably talking about the Fani train. Well, the Fani train is going to keep on coming. We're kind of okay with that because she's such a disaster. Roger Needham says, I'm a drain cleaning technician and this odor of mendacity smells worse than a basement full of sewage. It's absolutely disgusting. Yeah, you expect a sewer to be stinky. You don't expect a court of law and a DA to have an odor. We got this one from Tobo, but many of them do. Tobo says, Sandra Day O'Connor was right about the election of judges. It's a very bad idea. This one from Sandy says, Judge McAfee kicked the can to the Court of Appeals intentionally. He gave them enough findings of fact to kick Fani and Fulton County out while preserving the due process rights of Fani when she gets prosecuted later. McAfee had the ultimate duty to preserve the legitimacy of the court, the justice system. He can look his kids in the face and say he did the right thing. Now it's up to the Court of Appeals. We can agree to disagree on that one, Sandy, but I think that is maybe a strategy. Maybe the Court of Appeals will do that and fix his mistake, but he twisted himself in writing that. Like he knows he did a bad thing. Like, when a dog knows they did a bad thing, he knows, but he's, what's he going to do? ELF is here. What's up, ELF, our newest supporter? Sandy says, legit question. How would people feel if McAfee said all we can think he should have said and Fani can't be prosecuted because McAfee violated her due process rights because she was never read her rights or because she found her guilty before she was charged? Well, he's not finding her guilty. Like, we're not prosecuting her in this court. The only question is whether she should be disqualified or not. Now, he should say, that's the only issue before him. So he could say, well, you committed perjury in my court. I don't find you credible, so you're disqualified. Now, he's not prosecuting her. So if anybody else wants to, the state AG or something wants to investigate her, that's fine. But she committed a new crime in his courtroom. I don't think he's finding her guilty. He's just disqualifying her. And I think he had every lawful right to do that. And he should have, because it was a disgusting thing that happened. Now, to be fair, like, there's a consequence of disqualifying her. If they're disqualifying her, there would have been a lot of political reaction to that, right? They would have, Trump is winning again, and like, it may have caused, like, this may not be the worst thing that could happen. Remember, I said that the worst thing that could happen would be Fani goes and we get somebody who's very competent who comes back in, who gets everything right back on track, who is seen as credible and legitimate and convicts Trump and all the other co-defendants like that. Like, that would be bad. She is an albatross around the neck of this prosecution. And I think she overshadows the others. And I think she delegitimizes the whole thing. So the fact that she's on it, there's not necessarily, if she was off of it, they'd all be crying foul for the remainder of the election. Now they're stuck with Fani. And I think they even realize it's a bad thing. That's why Weissman was saying that he still thinks that she should resign. Travel agent Amy, my friends, if you need a cruise guy like Nathan Wade, who's much more ethical, travel agent Amy can help. Says, I would love to be a fly on the wall when Fani and her office are kicked off this case. It would be a lot of fun to hear. And I'm not joking about travel agent Amy. We've sent some emails back and forth. She's got some good stuff over there. So if you're looking for a good person, travel agent Amy's the one. Hey, it's the Munkets. Tony Hey Munkets bringing in new members. We got Tom H is coming in. Thank you, Tony. Old Drill Sergeant. Judge Mental is here. We got a lot of those. Diana M and Stina M all coming in courtesy of Tony Hey Munkets, bringing in 5 new members in the house. Thank you, Tony Hey. We got Steph D is here. Says, as a woman, Fani infuriates me. Happy to be here, though. We're glad you're here. Thanks for joining us, Steph D. Membo for 1 month. Well, yeah, apparently she's not your role model, Steph. Is that what you're saying? She doesn't represent you. You're not interested in all the Fani activities. That's good. Isla B says Fani should be tried and spend a while in the Fulton County Jail after she is disbarred. Well, I'm sure there's a lot of people who've been prosecuted for things like, illegally appropriating a government benefit, misappropriating government funds, all those types of crimes. Check fraud, those types of things, public benefits fraud, those types of things. She certainly committed that. She just was funneling it, whitewashing it through her boyfriend. Dolphin Fan is the man in the house, is bringing in more membos. Thank you, Dolphin. Fizbin G, Mitch M's coming in, Brian D, we got Mary M and Marco K, all coming in the house, courtesy of Dolphin Fan is the man, bringing in our newest of membos. We got this old guy says, it's obvious that big Fanny stinks in Georgia. Sure does. It's a noxious odor that won't leave the room. We all know what it is. It's Fani. Someone needs to tell her. Sometimes people don't know, but maybe she just doesn't know. She's like, no, I thought that hearing was an award ceremony. This old guy, good to see you. Gag says, if the appeals court were to let Fani remain and the case to go forward tainted, would that be seen as indicating the Georgia legal systems want low standards for their prosecutors? Yes. I mean, basically this conduct has been endorsed, right? Or I wouldn't say endorsed, but it's been, there's no consequences for it. Really. There's precedent that says that you can do what Fani did and it's not an actual conflict. From Judge McAfee. Well done, Judge. Lover of Green says, to this day, I still see woke streamers saying they got the coof. Guys, it's over, okay? It's been 4 years. Just drop it and move on. Saying I think people can still, you can still get sick. Like you can still get sick. I see what you're saying. So like they're telling you about it. That's probably what you mean, right? So like they come out, they're telling you about it, like, guys, like I'm so sick again. You'd never believe it. My fever. You're like, oh, really? Well, get well soon. We hope everybody gets well soon. It's still a thing, but obviously I think it's like a lot different than it was originally. Hey, this one is from Sandy on Locals, says, this filing from Trump has to result in the removal of McAfee. Now, all the parties' witnesses were attorneys. Fraud upon the court requires an attorney to trick the court and get a decision based upon the trick. If McAfee rules on this case after a fraud upon the court is known or should have been known, he blows up his judicial immunity and can be prosecuted for civil liability. From Sandy, the Rubos are here. Yeah, the Rubos have this one saying, regarding the MV Dolly, the website Baltic Shipping, which has details on all cargo ships, has a Ukrainian master listed on its Dolly webpage. We saw it ourselves. Then the page was changed hours later and the Ukrainian was removed. That's pretty weird. And we know the Rubos. Rubos around on Locals. So that's a very interesting report there from the Rubos. So the MV Dolly says that there was a Ukrainian master and then they deleted that. So that looks like this one right here. There it is. So ID, whatever, master, Ukraine, salary, 10 grand a month, US, applied for the master. Interesting stuff out there. Interesting reports, my friends. Yes, indeed. Okay, Donut Mind Me is clipping for us today. Thanks, Donut. We got Isla B. Isla B. What's up, Isla? Bringing in new membos. We got Richard Tatership, Tornado S. We got more Sick Cat, Irene A, and David. All gifted membos, courtesy of Isla B. Thank you, Isla. Thanks for being a membo. Look at that handsome pup. And thanks for joining us and bringing in new friends to join us. Welcome aboard, our friends. We got Cowboy Rob says, have you not noticed the big former prosecuting attorney that both Tish James and Fani Willis and Nathan Wade all went to go visit before? I have a feeling that is going to come back to bite Miss Harris. Oh, like they all went to visit VP Harris. I see. Fani, Nathan. I know Fani did. Did Tish go visit Harris? I know Nathan met with the White House counsel. Good to see you, Cowboy Rob. Thanks for the lovely dono. Very nice to have you here as a membo. And Rocky Water, as we wrap it up on the day, Rocky Waters here on Local says, "'Twas a great week, is a great day, and cheers to all watchers." Peace. From Rocky Water. Thank you, Rocky, for saying that. Peace to you, my friend. It has been a beautiful week and a heck of a day, and it's a good Friday indeed. Let's say hello to our friends on X before we wrap it up on the day and head on over to watchingthewatchers.locals.com to see who is joining us over there. We do have some comments. What's up, T. Partain? Says Judge McAfee appeared to have a conflict too. Jurassic Carl calls it Fanny Gates. We got Fred Pedamonte. Says, Rob, I spoke to Norm Pattis today. He's near me in Connecticut. Saw him on Laid Back Law and asked him about the Proud Boys trial. Brilliant attorney. Yeah, shout out to Norm Pattis. Cool. That's cool comment, Fred. Danny McWilliams, Salty Sarge are over there. And it's very nice to see all of our X friends. You can follow us and join us over there at Rob Govea ESQ on the X platform. And it's always fun to follow your other watchers out there so you can connect with other people out there in the wilderness all across the fruited plain of the interwebs. That, my friends, is going to be it for us on the day. We are going to go hang out for a bit at watchingthewatchers.locals.com, which is where we do our Saturday stream. We'd love to have you come and join us. Come on by. Links are down in the description below. RobertGovea.com, where we put our PDF documents. We have our calendar up now. We have our newsletter that's available. So check that out. Links in the description. And of course, WatcherLodge.com. More on that coming next week. Going to try to get on a regular schedule there. But that's it for us on the day. On the week, want to thank our mods and our meme smiths who mod down the fort for us and keep things nice and orderly. Our friends, the Anticus Prime. We got K-Bean in the house, Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo. We got Zach Nichols, John Allen, Janak909, Dog Digger, and Donut Mind Me, all modding the fort down for us. Our friends Sleepy Dog Lee, Nathan N810, and of course Geegum Geegum, modding the fort down for us and memeing the fort down for us, keeping things nice and beautiful. But that, my friends, is it for us on the day. It has been a heck of a week, and we got a lot more ahead of us next week. But we pause there for the weekend, and we break, and we hope that you have yourselves an amazing weekend. Of course, it is Easter Sunday this weekend, and so if that's something that you enjoy, we'll be doing that. I hope you have a beautiful Easter and an amazing time with your friends. Hopefully, no matter what it is you're doing, however you're spending your weekend, I hope you get some time to recharge those batteries, restore those energy tanks, and rejuvenate that spirit, because we're going to come back here on Monday to get into it all again. We're going to have a lot of business to attend to, and we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend and an amazing night, my friends. I'll see you right back here on Monday. Bye-bye.